Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. Say, I call you Jireh. You're my provider. I call you Eunice. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. You're my provider. I call you Eunice. You are my battle. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Uya matinyana. Uya matinyana. Uya matinyana. Oh, uya matinyana. Yeah, so uya. Uya matinyana. Uya matinyana. Yeah. Uya matinyana. Uya matinyana. Say, I call you Jireh. Say,
Okay,
I call you Nisi. You are my God.
cut
I call you Rapha.
10 seconds.
You are my healer. Say, Lord, you are my everything. Yeah. Are you ready, everybody? All right, listen. Will me ground cover? What to say?
Hello, lovely people, wonderful community. We are here with you once again on a very lovely Saturday afternoon, the very first one in the month of June 2023, and we're coming your way with the community and the law. My name is Ureku Frimpon, and by courtesy of BWF Solicitors, we're coming your way with some very lovely discussion on the topic how to make a 20 years longer residence leave to remain application successfully. How are you going to do that? Let's get into it together live on BWTV, BW Radio, BWF Solicitors on Facebook and YouTube. Let's go.
Charles is here now.
Hello, lovely people. Once again, thank you very much. Your time, your space, and even the concern you show is so much appreciated. My name is Ureku Frimpon, and welcome to another edition of the Community and the Law, brought to you by BWF Solicitors. BWF Solicitors are trusted partners when it comes to the law. Located on the 4th floor of the Anna House, 214-218 Tottenham High Road, Seven Sisters, London, N15 4NP. When you want to get there via public transport, take the Victoria line, alight at the Seven Sisters train station, use exit number 2. It will bring you to the main entrance of the Anna House, climb up to floor number 4, and you find BWF Solicitors. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Now, when it comes to all issues of the law, applications for immigration and nationality issues, family law, buying a property, making sure that your family is well catered for, wills and probate, and all the other things that I'm talking about, BWF Solicitors is the sure bet for you. Call them now on 0208 493 7340. And the number again, 0208 493 7340 or 077 127 61884. 077 127 61884. Now, today we are here with a discussion on the topic how to make a 20 years long residence application and how to do it successfully. And I have the delightful duty of letting you know that our friend and our partner and our friend from BWF Solicitors, Lawyer Charles Asma, is our guest. He is going to lead us to discuss this very particular important topic. So, Lawyer Charles Asma, let me say thank you very much for coming on board. Welcome and good afternoon once again. We will be coming to you pretty soon. But before then, let's say thank you to BWF Solicitors. Then, after that, we'll look at the nugget, that piece of information that we need to have to put in our pockets and build our knowledge on that. And we'll be looking at that right after these.
This is our world.
Kwaku,
Here we are in our community.
yeah,
There
your
are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects
Yeah,
of the law.
let me call you.
Family,
Let me call you.
civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
BWF Solicitors are trusted legal partners, and we want to say thank you to all of you, those of you who have joined us. If you have, let's get into our chat room, and of course, put your comments in the section below. We're live on Facebook, we're live on YouTube, we're live on all the other social media platforms. And what I want you to really do is to pick up the link and share it in your WhatsApp groups, in your various groups that you have, so that people will have the opportunity of joining us to learn with us together. Now, the nugget we had from the beginning of the week was about the deprivation of British citizenship. You would realize, those of you who have followed us, Uncle Ben has dealt with that topic so very extensively. Now, the deprivation of British citizenship is a decision to deprive someone of their British citizenship, even where it would leave them stateless. And this can be made if they have conducted themselves in a manner seriously prejudicial to the vital interests of the UK, and if there are reasonable grounds for believing that the person is able to become a national of another country or territory. Section 44A of the British Nationality Act of 1981 is where I have quoted this one from, or BWF Solicitors is giving us this one from. So I take a read of it again. It's a decision to deprive someone of their British citizenship, even where it would leave them stateless. And it can be made if they have conducted themselves in a manner seriously prejudicial to the vital interests of the UK, and if there are reasonable grounds for believing that the person is able to become a national of another country or territory. The thing is quoted from the British Nationality Act, Section 44A. We'll be asking lawyer to help us understand this, unpick the various aspects of it, and also get us to understand it. And as I said, if you go to our platform, there's a BWF Solicitors platform on Facebook and YouTube, you realize that last Friday, Mighty and Uncle Ben dealt with this issue. So the further explanation we'll be giving would just enhance your knowledge and deepen your wealth of it. That even though you may be giving a British citizenship, it could be taken away from you. What are the reasons? I know lawyer will be helping us to unpick that. So take note of that. And maybe later on in the program, I will be conducting my quiz on this one. So just be on the lookout. That we'll be looking at a scenario, a case study of where somebody may be deprived of his or her British citizenship. Now, what is that? And I say again, it's a decision to deprive someone of their British citizenship, even where it would lead them stateless, and can be made if they have conducted themselves in a manner seriously prejudicial to the vital interests of the UK, and if there are reasonable grounds for believing that the person is able to become a national of another country or territory. Remember when I quote, I give you the source. Section 44A of the British Nationality Act of 1981. Nana Bob, thank you very much. Good day, bro. Kweku and lawyer Asma, thanks for the good work. Thank you, Nana Bob, as well. Abena Ativo, my dear sister, how are you doing? Thanks for joining us. Yes, so what we need to do really is to come on board, pick up the comments and share. Nana Sapon also is on with us. Nana Sapon, thank you so very much. We have other people coming on board, I believe, on a very lively Saturday afternoon like that. You are all ready on board to learn so much. Now let's take another message from BWF Solicitors and we'll be right back.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects
Yes,
of law,
yes,
family
yeah.
law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Okay, thank you very much, Chiwo. You're on board. Thank you very much for joining. Tilly Duma, Nana Achimang, and all the wonderful people that are on board. Thank you very much. Ademonukum is here. Good morning. Good afternoon, friends and family. We are so very pleased that you guys are with us. Now let's go to our nuggets and pick the thoughts of lawyer Charles Asma once again. A decision to deprive someone of their British citizenship, even where it would lead them stateless, can be made if they have conducted themselves in a manner seriously prejudicial to the vital interests of the UK, and if there are reasonable grounds for believing that the person is able to become a national of another country or territory. With that, I welcome you, lawyer Charles Asma. Good afternoon.
Good afternoon, Brakoku.
How are you doing, boss?
Very well. How are you too?
Very well, thank you. We have the opportunity of meeting again, and we're grateful to God for all the mercies He's shown us. Maybe I'll get you to say your greetings and your thank yous first, and I'll come back to this nugget. So, you have us ready to listen to you.
Thank you very much. So, a very good afternoon to you, cherished viewer and listener. We have met again on this program to learn and to flourish. We are grateful to you for your time, and we thank BWF Solicitors for the opportunity to come your way once more. And today, let's stay glued, share, and let's learn.
Okay. All right. Thank you very much. We're sharing, we're learning, and we're doing this together. So I will reiterate that pick up the link, share it, and invite people to come on board. We're live on BWTV and also live on BWF Solicitors Facebook, live on BWF Solicitors YouTube, and all the social media platforms. Now, I read this quote from Section 44A of the British Nationality Act of 1981, and it's talking about the deprivation of British citizenship. Take us through it.
Thank you very much. So, viewer and listener, we are looking at deprivation of British citizenship. What it means is that once you have become a British citizen, the road has not ended for you yet. And therefore, you have to guard your conduct very, very well in the UK. Because the law, as we have read, Section 40, I'll take you a step back. Section 40, subsection 4 of the British Nationality Act 1981, first off, says that the Secretary of State can make a decision to deprive someone of their right as a citizen if their behavior is not conducive to the public good. Simply, if their behavior is inappropriate and can affect the wider interests of the nation, the person can be, that right of a citizen can be taken away from the person. However, then it gives a duty on the Secretary of State to make sure that the person will not be rendered stateless, and that is Section 40, subsection 4. Then we move forward to Immigration Act 2014, and that introduced a very high discretion for the Secretary of State to take without considering whether the person will be rendered stateless or not. So Section 40, subsection 4, capital A of the British Nationality Act 1981 that we are looking at was actually brought into being by the law of Immigration Act 2014. So the introduction now gives the Secretary of State wider power to take somebody's citizenship from them if their behavior is not conducive to the public good, without considering whether they will be rendered stateless or not, and especially if there is every indication that the person has somewhere else to go. So there are three things here. The first thing is that the Secretary of State has power to take away people's citizenship from them. And here we are looking mainly of foreigners who have acquired citizenship. So first off, they have their original countries or nationalities, and they have acquired country or nationality. So that acquired nationality can be taken away from you, and that's the power the Secretary of State has. The Secretary of State has to check that the person's behavior is not conducive to the public or the wider interest. And here we are looking at conduct, criminal conduct, fraudulent conduct, and any conduct that renders the person's um, involvement in the day-to-day activities of the nation inappropriate or unconducive. Now, once the Secretary of State has established that the person has committed an offense, and that offense means that the person cannot be allowed to be part of the British society, will have to take steps to take the right away of a citizen. Now, the Secretary of State doesn't have to check whether that will make the person stateless or not. So, mind you, before the Secretary of State has to check. Now, the Secretary of State doesn't have to check whether you are going to become stateless or not. So, whether you are a refugee and you have become a citizen and you have committed an offense, you can be sent back to your country where you came from as a refugee. So, let's bear that in mind. However, it says that the Secretary of State must have a reasonable grounds to believe that the person has another place to go. Must have a reasonable ground to believe that the person has a place to go. What it means is that there's no reasonable grounds to believe that the person has another place to go, or the person is a national of another country, then that discretion is narrowed. How would you prove that the Secretary of State or how does the Secretary of State prove that the person there is reasonable grounds and belief the person has a place to go? The person, first off, is a foreigner who has acquired citizenship of this country. That means the person came from somewhere.
Yeah.
They have parents who can identify themselves with another country, and therefore they can also identify themselves with that country. So if you came from another country, let's put it simply, if you came from another country, you have lived in the UK, you have become a British citizen, bear in mind that we can trace your route back to where you came from. That's the starting point. And the second point is that if that country allows for dual nationality, then it's obvious that you have somewhere else to go.
Okay. Now, lawyer, if I could just take a quick step back and ask, you're talking about the public good. The person's conduct is against the public good. How would we define that? Would it be just any criminal offense? Or if it's a criminal offense, there must be a higher degree of intensity of that?
Right. So we are looking at activities that put the whole nation's interest at risk.
Okay.
And first off, we are talking about terrorist activities. We are talking about money laundering activities. We are talking about child trafficking activities. We are talking about modern slavery. We are talking about fraud, high-level fraud. So anything that affects the national interest of Britain can be said to be seriously prejudicial to the interest of the country. So
let me kind of break it down, maybe for the purposes of understanding it very well. Somebody lives in this country. The person has been given British nationality, and it's very recalcitrant. Traffic offenses, other things, going to prison and coming out several times, and the rest of it. Could that be considered as against the public good?
I mean, there are instances where a foreigner who has committed an offense and has been imprisoned or given custodial sentence for 12 months plus can be asked to return to their country. A foreigner. Okay. In this conversation, we are not talking about a foreigner. We are talking about a citizen of Britain whose behavior is not conducive to the wider interest of the nation. So bear in mind that we are talking about a citizen who we are making a decision to say that we want to ostracize that person from our list because of their behavior. But in
Right.
ostracizing that person for that behavior, you want to consider whether the person has elsewhere to go.
Right.
So we want to know what behavior qualifies the authorities to ostracize you or to deprive you of your right as a citizen. And we have touched on the pertinent ones. Traffic offenses will not warrant deprivation. So it's seriously prejudicial to the interest of the nation. So we are
Okay.
looking at such international dimensional offenses, things that
Right.
can affect the wider interest of Britain. So Britain is guarding against terrorist activities. So if anybody is supporting that activity, then the person is an enemy of the state. Britain
Okay.
is against child trafficking because we are looking at safeguarding and protecting children. So if you are engaged in child trafficking for whatever reason, then you are against the common good of the state.
Right.
If you are engaged in modern slavery, you take people from abroad, bring them to the UK, and allow and force them to engage in slavery activities. Meanwhile, Britain has supported the abolition of slavery long ago. And therefore, anything that suggests that slavery is being brought back in one way or the other, that activity is frowned upon by the state. We are talking about money laundering activities, siphoning funds from wherever, for whatever reason, across borders. And that is serious offense. So all put together will trigger the seriously and prejudicial activity that affect the interest of the state.
So, if the Secretary of State makes that decision to deprive anybody of his or her nationality, could that be appealed against?
So prior to the new law, the provision section 40, subsection 4A, people could appeal under the old law. However, it says the Secretary of State has the power without even thinking about but we've also discussed the fact that before that action is taken, the Secretary of State will have to go through, carry out its own assessment to ensure that one, that conduct is very serious and prejudicial to the state. Two, that person has nowhere else to go. That person has somewhere else to go. And the assessment has concluded that they have at least a second country or a second home to go to. And on that basis, the decision is made purely in the interest of the nation. And on that basis, there's no point of, okay, I'm not happy with this and therefore I'm going to appeal. All this law is saying is that the Secretary of State can do what is right for the state. So before we even decide to misconduct ourselves, let's bear this in mind because there will be no second chance.
So, to the ordinary person, what we can say is when you're giving British citizenship, when you have been giving a British passport, you've sworn allegiance to the king, it may be taken away from you if your conduct is against the public good. Can we summarize it as such?
Yes. So simply your behavior should not be one that can put the nation at risk.
Okay. All right, folks. That's our nugget, and it's talking about the deprivation of someone's British citizenship. And it says that it's a decision to deprive someone of their British citizenship, even where it will leave them stateless. And this can be made if they have conducted themselves in a manner seriously prejudicial to the vital interests of the UK. And if there are reasonable grounds for believing that the person is able to become a national of another country or territory. Section 44A of the British Nationality Act of 1981 is what we have discussed. And Lawyer Charles Asma has been so gracious to just expand it, unpick all the various parts of that, and has let us know that whatever it is, your British citizenship could be taken away from you. And the Secretary of State has a right to do that and may not even consider whether you will be declared stateless or not. If your action and your behavior is not for the public good, and it is against national security and all the other things as lawyers discussed, definitely it could be taken away from you. It brings us to the end of our discussion on our nugget. And remember, I may be asking you a question on that. Remember, we have our quiz segment, which is the last bit of the program today, and we'll be doing that. So keep that discussion in mind. We'll be going to discussing the topic how to make a 20 years long residence leave to remain application successfully. Lawyer is going to do that for us. And remember, we are here courtesy BWF Solicitors, are trusted partners when it comes to the law. Call them 0208 493 7340 or 077 127 61884. 077 127 61884. BWF Solicitors. We'll take a message and we'll be back.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214-218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
How to make a successful 20 years long residence application. 20 years long residence, what is that? And who is found in that category? What are the things that we need to see and know and also to take note of? Who makes that application? How successfully can you make that? Can you do it on your own? Can you help somebody else to do it? Yes, I know you can help somebody to do it because I'm doing that now. I'm directing you to BWF Solicitors. Welcome once again to the community and the law. Lawyer, 20 years long residence, what is that?
Thank you very much, Brakoku, and welcome once again, viewer and listener. Today's conversation, we are looking at very important aspect of the immigration rules. So let's have our starting point. Somebody has entered the UK as a visitor.
Right.
When they were coming, they had decided that they were only visiting and return later. For whatever reason, they did not return, and they're in the UK. They have a choice to go back, and they know that if they go back, they may not come back. So they have decided to stay on. That's one. Somebody else might have also come in through whatever means, and they have decided to stay. Now, whilst they are in the UK, because their visa has expired, they have become unlawful resident, because let's put simply, they become illegal resident.
Okay.
Now, as an illegal resident, you don't have any right under the law, and therefore you have the restriction to the point that if the authorities pick you up, you'll be asked to return to your country.
Right.
That's a removal or deportation. Now,
Okay.
the rules have been relaxed to the point that there is amnesty of a sort, and I say this with a very um, careful consideration. Amnesty of a sort, and the amnesty is that the law has made it possible for those people who are not legally resident in the UK to regularize their stay,
Okay.
so that they become lawful residents. Now, what the law is saying under paragraph 276 of the immigration rules, appendix FM, is that once you have lived in the UK for 20 continuous years, you qualify to be given amnesty to regularize your stay.
Now, Lawyer,
Yes,
you said 20 continuous years. It doesn't have to be broken. It has to be 1, 2, 3, 4, 5, and counting to 20. Is that what it is?
yes. So from the day you established presence in the UK, from the day you entered the UK up to the day you decide to be considered for this amnesty provision, you have to count 20 continuous years. The law is continuous residence.
Where do
Now,
you start counting from, if I may ask?
the very day you entered the UK.
Okay.
If you want to do your application today, and today's date is the 3rd of June 2023,
23.
count back 20 years back. That would be 2003, 3rd or 2nd of June 2003.
Okay.
So if yours is less than 20 years, this conversation will not be for you, because you are not yet 20 years.
Okay.
So first off, 20 years,
Right.
continuous residence. The question is, do you have to be legal? The whole essence of this conversation is that you are illegal. That's why you are being considered for this. So you don't have to be legal. If you are, the moment you are legal, then it will not be 20 years. We are looking at 10 years under paragraph 276B. 10 years continuous lawful residence. But here we are not talking about unlawful residence. That means whether you have been illegal or not, you'll be considered under this provision. And to be fair, we are talking about those who have entered and have no right, legal right, and they want to ask how do they regularize their stay so that they can be lawful, return to their country, and come back to be able to work and to be able to live their lives without any fear or any apprehension. Now,
By the definition, if I may ask, somebody comes in here as a visitor, was given 6 months. After the 6 months expires, he decides not to go. So the unlawful residence starts from when the 6-month visitor's visa expired. So we can count from there. Could that be right?
we are looking at when the person established presence. So they entered the UK, the date they entered. So the first day of arriving in the UK is the starting point.
Okay.
Then they have, so within that, they were lawful for 6 months. But even that 6 months is not, because when they were coming, they said they want to spend 2 weeks or maybe 1 week or 1 month. And they have gone past the 1 month, they have gone past the 6 months, and they are now into the 20 years. So we are looking at the starting point is when they arrived, the arrival stamp date.
Okay.
Now, let's establish this point as well, that we said the 20 years should be continuous. So
Yeah.
what breaks the chain?
Uh-huh.
If you return to your country, it breaks the chain.
Okay.
And if you are imprisoned, custodial sentence, it also breaks the chain.
Right.
So these are the two uh, factors that can break the continuous residence chain. So let's bear that in mind.
Okay.
So when you go back and you return after 1 year or two, you have returned, and therefore calculate it will start counting from when you returned.
Right.
All right. So that's the starting point. The second thing is, all right, I've been resident in the UK. Now I'm 20 years. How do I pursue this application successfully? And our
Mhm.
emphasis is on how successful the application should be. So you are not just trying your chances or luck. You want to start the application and make sure that you are 100% sure that you will succeed. And that's our
Okay.
priority as BWF Solicitors practitioners.
Okay.
So how do you start? Ask yourself, am I 20 years? That's first question. Second question, do I have evidence to prove each of the 20 years?
Mm-hmm.
And the third one, have I had the chain broken? I.e., have I returned and come back, or have I been in prison? Because the years
Yeah.
of imprisonment you have to deduct, even though you are in the UK, but the years of imprisonment have to be deducted from the 20, and you have to top it up by staying extra. And if you return to your country and you came back, you will start counting from when you came back. But granted that these factors are not there and you are 20 years, how do I organize myself?
Mm-hmm.
We are making reference to case law. So, paragraph 276 of the Immigration Rules ADE says that if you have lived in the UK for 20 years continuously, and whether there is suitability or no suitability issue, you apply to the Secretary of State for consideration. Secretary of State will have to consider your application and give you limited leave to remain. So you are going to get limited leave to remain, 2.5 on the 10-year route. And bear in mind, this is not indefinite. You only get indefinite under 276B if you have continuously lived for 10 years. Then after 10 years, you apply, you get indefinite. But if you haven't, and you are making an application for you to be considered for some regularization, you are talking about limited leave. So that's the difference. Now, case law, that is the underpinning authority, is the case of NA. Case of NA talks about reasonableness, whether it
Mm-hmm.
will be reasonable for the Secretary of State to look at you having lived in the UK for 20 years and to tell you that go back to your country and start life afresh. That will not be reasonable,
Okay.
because over the past 20 years, you have formed new friendships. You have severed ties with the old friendship you had in your country, even to the point that you might have even lost a lot of the families that you left behind, and therefore you may not even have any family to go to. So to be asked to go back and start life afresh is not good enough, and therefore will be unreasonable. So that's the point you are making to the Secretary of State for consideration on your behalf or in your favor.
Okay.
Now, so why do we say that it not be reasonable for you to go? Somebody who now has friends here, somebody who has acquired culture here, somebody who speaks the language here, somebody who now has a new home and a new community may struggle to start afresh after 20 years of living abroad. And therefore, the rule is that once they make this application, case law requires that they will be considered to be issued on the basis of reasonableness. The
Okay.
next case law is the case of Mahmoud. Mahmoud says that once you are in the UK unlawfully, you may have done things that the law did not permit you to do. For example, you worked in the course of the 20 years, but the law does not permit you to work if you do not have right to work.
That's right.
So you can see that the amnesty provision, which is paragraph 276 ADE, makes provision or consideration for no suitability element. And no suitability is that you have already committed immigration offense anyway. The simple fact that you did not go back after 6 months or when you came and you have stayed for 20 years, you have broken the immigration rules. So
Yeah, obviously.
you do not meet the suitability rule. However, because this is an amnesty provision, suitability consideration is not forcefully taken against that individual because the person is applying for consideration on amnesty grounds. Now, Mahmoud is saying that because of that, if you have survived because you had to work, and in the course of the period you worked, you can rely on the evidence of work to prove your residence. Now, what do I mean? I mean that once you are in the UK and you worked unlawfully, people work in their own names. People work in
Other people's names.
alternative names. If you worked in your own name, even though you did not have the right to work, and you were issued with pay slip, the pay slip will have your name, will have address to suggest that you were living in the UK. And because that is your name, you can use that piece of evidence to prove that you have been in the UK for that period, and that will count towards the 20 years continuous residence. What if you worked in alternative name and therefore the name on the pay slip is not yours, but you worked? That means you have to find other means to prove it. How do you prove that if it's not in your own name? Now, there are people who will be working and they will be given name badge. You know, the name badge we have from our employers.
Yeah.
If you have a name badge, your name is there. That is not pay slip, but it has your name. It has the year it was issued or the date it was issued. And it suggests that it was issued in the UK. That will be a piece of evidence to corroborate your claim that you have been living in the UK that period. Now, why is that important? You have to put all evidence together to build a case for 20 years.
Right.
It's not a case of I have been in the UK for 20 years. I have not returned and I want to make application. It is your case to prove. The law is that the Secretary of State will consider an application under this provision if the person can prove that they have lived in the UK continuously for 20 years. The applicant must prove. So you don't put the duty or the responsibility on the Secretary of State to say that, oh, I know that you haven't returned and therefore I can vouch for 20 years. No, you have to prove it. And to prove, you have to bring every documentary evidence. What if I ask my friends and family to vouch for me? People who know my church. Mind you, that evidence is not corroborative. And it's just like reference. No family member or friend will give unfavorable reference to anybody. You agree with me?
Yeah, I do.
And therefore, the Secretary of State takes the view that such testimonials are not adequate evidence that you have lived in the UK for 20 years. Because those people will not testify against you anyway. So you have to make sure that you have proven enough independently. So what are the independent evidence?
Yeah.
If you have worked and you have pay slip, that is independent evidence. But I'm not supposed to work. How will I use my pay slip?
How will I know? Yeah, that's it.
The case of Mahmoud support the view that even though you were not supposed to work, you worked and you lied to the employer that you qualified to work.
But that is that in itself not an offense? Lying to the employer, deceiving the employer to give you employment just for you to be able to live here in the UK. That in itself, not
We are looking
something that
at
could be punished?
we are looking at who is taking the offense. The Secretary of State is not taking offense because you haven't lied to the Secretary of State. If the
Okay.
employer wants to take offense, they should have taken offense as soon as they realize that he didn't qualify to work for them.
Right.
So, it's a separate conversation. We are dealing with encounter with the Secretary of State. So, the Secretary of State, under the case of Mahmoud, the case law says that the Secretary of State is hearing about this the first time that this person worked at a point in the UK. And as a matter
Okay.
of fact, this person is telling the truth, isn't he or she? Yeah,
Well, the person is turned around to tell the truth anyway.
the person is telling the truth to the Secretary of State for the first time. And the person hasn't lied. So it's true that they have worked illegally. But they are not telling the Secretary of State whether they worked or not. They are telling the Secretary of State that they were in the UK at a point, and this is the piece of evidence.
Right.
And the only way to prove that you were in the UK is to disclose to the Secretary of State that you worked at a point, you got this piece of evidence, and that shows that indeed you were in the UK, not elsewhere.
Lawyer, we're talking about counting the 20 years, and one thing just struck me. If I had a visitor's visa, for instance, and I overstayed it, but along the line, I realized that I could go out of the country and come back with a reasonable expectation that I could find a job, or somebody's promised me a job one way or the other. When I come in, would I be able to use that period when I was a visitor, overstayed a bit and went away, and count that as part of my long residence or whatever period I need to do the reckoning for?
Right. So what we have to bear in mind is we have a waiver for breaking continuity where you are lawfully resident and for whatever reason you went abroad and due to illness or some similar reasons you were not able to return. That one concession is given under the relevant provisions. But we are looking at somebody who says they've lived in the UK continuously for 20 years.
For 20 years, yeah.
That I went back when I came, spent, let's say, 5 months. I had 1 month left and came back to continue living in the UK.
Mm-hmm.
Let's establish, when did this person enter the UK to continue to start that long journey?
Right.
Is it the second attempt or the first attempt?
Well, obviously the second.
Exactly. And therefore, we are looking at your long residence from the point where you came and not returned.
All right.
Right. So that's the starting point in terms of counting the time. So we know, and also you do not count when you are in prison. So if in the course of the 20 years, you went in for 2 years, then it wouldn't be 20 years, it will be 18 years, even if the 20 years is up.
Okay.
Because technically, when you are in prison, you don't have liberty.
Mm-hmm.
So that lack of liberty period is taken away. So that is that point. So once you count your 20 years, so let's assume that John has established 20 years, unblemished years, no break.
Mm-hmm.
John is asking, how do I start? John must provide the stamp, the visa stamp. That, of course, the visa was stamped at the point of entry, whether Heathrow, Gatwick, or wherever. Mm-hmm. John, over the 20 years, might have lost that piece of evidence. That's fine. If you've lost the evidence, your evidential starting point will not be that piece of evidence. It has to be something else.
Okay.
If John were to have that evidence, then we can say that John has the evidence, and therefore we are starting with the passport stamp or the visa stamp. But the visa stamp is not available. So what will John have to prove? John might have registered GP when he entered the UK. So that would be the first piece of evidence to show that they were in the UK.
Okay, now let's look at John's situation now, lawyer. John entered in 2003. He went round and round and was able to register with a GP in 2005. which means that almost 24 months it's gone off that he cannot prove because he doesn't have the evidence that he landed on this. The airline ticket probably is even gone. The passport probably he traveled on is nowhere to be found. But he registered a GP after 2 years. Does it mean that we're counting the start of his stay in the UK from when he can find evidence?
There are two things. John
I think I've lost lawyer's
Yeah.
sound. Okay.
Can you hear me?
Yeah, I've got you. I've got you back. Yes. Let's look at John's situation.
So John is looking at two things: physical presence and evidential presence.
That's right.
Physical presence, we know that John entered 2003. But in terms of evidence, John can start proving from 2005.
Yeah.
Those 4 years gap, John will have to find something to cover that. That is where we rely on friends and family and church, community, and so on and so forth. And this is where, if John was able to find voluntary work during that period, he can rely on the evidence of that voluntary work to cover that. But if John did not find anything and all he has is the 2005 evidence of the GP registration, then John has no choice than to rely on the testimonials from friends, from church community, and from other sources. However, that has less weight.
Would that be discarded altogether or maybe considered of a 10-20% weight?
The Secretary of State will say that this is not reliable evidence because it's not corroborative. However, if the matter were to go to court, court will take a different view. And the view the court will have is that, well, this person has witnesses to support the claim that he hasn't returned to his country since he came in 2003. The person, John, can also request the Secretary of State to give him access to his record, what we call subject access request. Once that is granted, it will have all his record, and that can also prove that I entered in 2003 on this visa. I have no evidence that I have re-entered. That means that I'm in the country. That is one piece of that one way John can support that claim. So you can see that there is always flexibility, and these things work better when you have someone who understands the law and the rudiment to support the application, because 20-year rule is very, very technical. So back to John. So John has able to prove that he has GP registration card. John is also able to prove that whilst in the UK, he was asked to vote because Commonwealth citizens can vote in the UK, and therefore sometimes you receive, if you are registered to vote, you receive your the voter card. That is also the poll card. That is also evidence that you were in the UK. In the course of the period, you received letters, you made school applications or college applications, you were doing short courses, you had certain things. You maybe had some photos taken. And caution with the photo. The photo must prove date and location.
Location.
So if the location is UK, that's fine. At the back of the photo or front of the photo, some of the cameras are able to show that. So that's fine. If you're able to prove the location and the date the photo was taken, then you find it difficult to prove that the photo was not taken elsewhere in the world.
Okay. Well, if you just joined us, Lawyer Charles Asma from BWF Solicitors is helping us to look at how to make 20 years long residence leave to remain application successfully. Now, he has gone into the definitional issues where we talk about 20 years, how to count them, and what evidences you need to get to put together so you can make a very successful application. We're coming your way courtesy BWF Solicitors, and well, if you just joined us, it's still live on BWTV and BW Radio, BWF Solicitors Facebook and YouTube pages, and as the community and the law. How do you make such an application? If you have any questions, if any comments, just put them in the section below on Facebook and YouTube, and we'll pick that one up and send to lawyer for him to address for you. So welcome back on board, and we're going over to lawyer again to look at how the application is put together and made. How to make a 20 years long residence leave to remain application successfully. Lawyer Charles Asma is with us. Yes, lawyer, let's go.
Right. So as the conversation progresses, we have looked at John. John has been able to establish that he entered the UK. He doesn't have the visa stamp. However, he has a GP card, or he took some photos when he first arrived with friends, and there is evidence on the photo showing the location and the date. That's good enough. Yeah. John was also able to prove that he registered from 2005 with a GP, and to date, he still has the GP record. John will request the GP to print all the evidence for him to show every year that indeed John was in the UK. The GP is not saying that John was in the UK, but the evidence we receive from the GP will be able to count and check and make sure that each year is covered. Because if, for example, 2012, there's evidence that appointment attended seen by Dr. F. That means John attended the GP practice on that day. Mm-hmm. And if John attended the GP practice, then it is not the case that John was not in the country. And therefore, John can prove that that is part of the 20 years. So 2012 is ticked off. Okay. Then we check 2000 and let's say 10. What do you have? John has bank statement to show, and the whole of 2010, January to December, he has bank statement. That's fair enough. That means he was transacting.
That takes off another year.
Somebody can say that, but hang on, bank statement. Even if you are abroad, you can run the bank, your affairs, your transactions. So why is that corroborative? So we're looking at the period. So we look at January to December. Every month, there is bank statement coming through. And also the transaction suggests that they were carried out in the UK. Then we can conclude that John was in the UK in 2010. John, in the course of the period, went to school. He applied. Unfortunately, he wasn't or wanted to go to school. He applied, but he wasn't given admission. But he was given some letters to say, sorry, on this occasion, your application
was not successful.
That is evidence that John was in the UK. Okay. John later was successful, went to school, he was given a certificate. That is evidence that he was in the UK. John made passport application because he wanted to renew his passport, or he wanted to get a new passport once the old one was lost. He applied, and in the passport, we see that issued in London. That means John was in the UK. Mm-hmm. So all the evidence will be put together, and each one is mapped so that we can conclude that 20 years covered. Then after this, we look at where the gaps are and how to mitigate those gaps.
Okay. So would a tenancy agreement, for instance, suffice for any evidence that John probably lived at 52 Grossbrook Avenue and lived here for this and that number of months and this year, that to show that John was in the UK? Would that be enough?
Yeah, tenancy agreement will support the claim that John was in the UK during that period or year. There is one case application I completed, submitted. The person had a lot of money transfer evidence. So even though he was unlawful or resident, he was mindful of his family, and every year he was remitting funds. And
Okay.
so I was looking for the name, the address, and the date on the money transfer evidence.
Evidence, right.
My argument is that this person was resident in the UK. During this period, he made transfers to the family. The date, the time, the address suggests that he was in the UK, and therefore that counts towards the 20 years residence.
Okay. Right. And the gaps, you mentioned that letters from the church, family, and friends may not carry enough weight. But if there are gaps of, say, 2, 3, even up to about 5 years, dotted in between the start and the end of the 20 years, would that be something substantial?
Um, of course, every year is very vital because you are looking at
Hmm.
20 full-on years. So every year
Okay.
is vital. You have to prove each year. However,
Hmm.
if the person genuinely has no evidence, but they were in the UK, what do? There's nothing you can do. So it's a matter of, do I rely on friend testimonials or go with nothing? You can't go with nothing. So you have to go with something, even if it is less weighted. So what on that basis the person will do is to get testimonials from church first off, then you come to friends.
Hmm.
Family,
Well,
we don't want to.
sorry for cutting in rudely. There may be this situation where the person is caught working at a place. Then the immigration officers will give you um, a letter or note to report at a certain point. And the expectation is that at one point or the other, they may send you back to your place. And it hasn't happened, and 20 years has elapsed. Can you use that as an evidence that you were in the UK and even at a point in time you were accosted?
So the starting point, Brakoku, is that you need documentary evidence to show that you were in the UK. Whether the
Hmm.
evidence is favorable or not
Or
favorable, on
not?
this occasion, you are using it to your advantage. Because what you are proving is that you were in the UK. Even
That's
if you,
right.
even if, as you said, you were asked to report, you were threatened with removal, all those things. Even if you made application, you were refused. That's evidence. You went to court, the appeal was dismissed. That's evidence. Whatever you have your name and date and address on to show that it was obtained in the UK, you can use it to claim the residence as part of the 20 years. So that will answer your question.
Okay. So with all these put together, lawyer, um, does it make the application kind of straightforward? Because as you mentioned, quote unquote, it's an asylum amnesty kind of. Sorry, that's the right word. It's an amnesty kind of. So having gathered the evidences, your entry point, the proof that you've lived here 20 years continuously, and all the other bits, how straightforward is the application?
So it's a tick box thing. The
Okay.
rule is the applicant must show that they have lived in the UK continuously for 20 years prior to the date of the application.
Okay.
And they must prove each year. So the question is, one, 20 years. Two, was each year proven? And three, has the person made this application? If all is yes, caseworker will consider favorably because it's a matter of applying the rule.
So then it's not a discretionary thing. It's just straightforward because you've met all the criteria.
Yeah, what is criteria driven?
Okay. Uh, the question is how do I survive 20 years?
Well,
Legally, I'm not expected to work. When I'm caught, I could be sent back to my home country and all that. How do I survive 20 years? And how do I do it?
that question is not a question of law. It's a question of fact. And you and I can answer that question. We are looking at people who have survived the 20 years. The conversation is not looking at how do I survive 20 years. The question is,
Mhm.
having survived 20 years, how do you regularize your stay? And therefore, if somebody has been, of course, people do survive. And the person who intend to make such application will find a way to survive. So having survived 20 years, we are looking at how do you make the application successful so that you don't continue to be illegal.
Okay. Well, somebody's just texted me and said that in this day and age where you need a share code to work, you need a share code to open a bank account, you need a share code to rent accommodation, they are taking away the opportunity of having any evidence. Is that correct?
The share code and those processes are not for illegal residents. They are for legal residents who have right to work.
Mhm.
But the person who is asking this question is also aware that even those who don't have the right to work are able to survive somehow through voluntary activities or work.
Okay. Right. Well, if you have any question, you have any concerns, you can put them in the comment section below on your Facebook page, YouTube, and all the other platforms, or you can text them to 07950422780. That's WhatsApp, or 07399208468. 07399208468. That's for our text messages. On the platform, one from Covenant Grace Law as this: how can a child who was born in the UK and now 7 years prove that she's been living in the UK for 7 years to enable her apply for indefinite leave to remain?
Right. So for the child to prove that they've lived in the UK for 7 years, just like any other person proving their residence, this is a child, so they might be going to school, so there will be evidence of school record. And anything, they might be, of course, the child will have GP attendance. So GP can issue all the GP record. So you are looking at, my child has lived in the UK for 7 years. If they were born in the UK, you are starting from their red book, the birth record book,
All right.
then through to their birth certificate, through to school record, every term, terminal report. So if you are a diligent and careful parent, you have all those record every term, every year for that child. You also go to the GP to have everything from there to cover that period. And it should be just like making application for a child for registration based on their private life, 10 years. You have to prove every year. So the same way, that child must prove 7 years every year.
Lawyer, this person says that he lived in the UK, came as a student, spent 10 years successfully, and completed all the education he needed to complete. He qualified for indefinite leave to remain, but did not do that. Returned to Ghana and lived there for about 10 years. He has come back to the UK and has realized that his GP records are still intact, his NI is active, and would want to relocate to the UK again. Would that person use the previous years as part of long evidence of long residence and apply for indefinite leave to remain, or he has to start counting again?
Rakoko, I think the question is answered somehow in the previous expositions, where we said that there should be no break in your residence, continuous residence. And a
Okay.
break is either you are in prison or you return to your home country and
Yeah.
came back. So if the
Right.
person stayed and got 10 years and left and they have come back, then they have to start.
That seems a
Unless,
bit unfair.
but what is fair? It is also not fair that they decided not to do anything and left.
Right.
Yeah, so fairness is open to interpretation. But the point is this, Brakoku, that if the person, maybe at that point, they didn't contemplate that they wanted to have any permanent residence in the UK, so they left for whatever reason. If they are returning, I don't know how they are returning. There are avenues where people will return, and after 5 years, they qualify for indefinite leave to remain. So I don't know the avenue through which this person is returning. But if this person is returning with their visitor's visa and for whatever reason they are not returning, then they have to stay for 20 years. If they are returning with long residence visa, then they have to make sure that the visa allows for settlement. And once that expires, they have to renew it so that they can count toward the 5 years or the 10 years and be able to qualify for indefinite leave to remain. It is
So in the case of this person, whatever number of years that he or she spent is count to nothing.
so, Bragoku, we have to understand that once you come to the UK, you see, the rules see you as either a visitor or somebody who has come to join family.
Mm-hmm.
Laws do not require you or forcefully require you to stay on to become permanently resident.
Okay.
You can choose to go back and come back. But whenever you choose to go back and return, you have to make sure that if the rules are not followed, you are coming back to start again.
Well, it's as plain and simple as that. Your text 0739920848. Send WhatsApp to 0795042270. Welcome on board, Akua MacDonald, and also Jima Boachi. Greetings to you as well. Odesheba Nana Kweku Meyedede. Thank you for joining us. Please, I'm about to renew my 2.5 for the third time next month. And I heard that they're going to make changes by the end of the year. Should I still need to do the renewal now, or I have to wait for the changes to take effect first? Thanks. Laura, this is one from Damwa.
Right. Okay. Now, Damwa must understand that the 2.5, when expires or about to expire, must be renewed.
Mm-hmm.
If even there's going to be something better than the 2.5 and it hasn't yet come, don't take chances. Renew it, because if you don't renew it and it comes, they will ask you whether you have something at all. So if the visa expires, then you have become illegal resident. So please make sure once it expires or about to expire within the last 28 days, you renew it. Having had that renewed, you can then decide, what do I do? Should I switch to something else, or I should continue to stay on that? Now, in terms of the changes, there are changes every year for different reasons and for on different points. So I'm not sure whether there will be, the change is for those who are on the 10-year route or the 5-year route. The changes will be something else. So don't gamble on the change that is coming. Just stay in your lane, renew when you have to renew, and wait for the change. When the change comes and you can switch, you switch. But don't wait. Just like when we're talking about Zambrano and Akinsenya and those who have 2.5. The advice was that if you have 2.5, renew it, because if it expires and your Zambrano doesn't go through, you've become illegal.
Okay. Well, we're still taking your texts and WhatsApp messages. 0795042278 for WhatsApp, and for text 0739920848, or you can put that in the comment section down below. One here from Joyce. I have a baby who has a settled status based on her father. I am an overstayer. Can I apply to regularize my status relying on my child? And if yes, what would I be granted when I do apply?
So this child has settled status. And because the child has settled status, the child has become a qualifying child. As a parent of a qualifying child who has no leave currently, the person can make application under Appendix FM to have her granted 2.5 based on the status of the qualifying child. The question is, where is the qualifying child at the moment? If the qualifying child is living with her, then she will make application as a parent living with their child. Now, if the qualifying child is living with their father, she will make the application as a parent, but on the basis of direct access because the child lives elsewhere and she supports the care of the child. So that's the difference. How will I proceed? You have to make sure that you get the right form, and the form will be because it's Appendix F application, so FLR FP form, and you go through the questions to make sure that you have selected the right category for yourself, and you apply, you pay the fee, then you provide the documents required shown on the checklist. If you are still not sure or if it sounds complicated, go to a lawyer who will make it simpler for you. Okay.
And to make it very simple for you and the simplest form, go to BWF Solicitors. That's the trusted friend when it comes to the law. 0208 493 7340 or 077 127 6188 for BWF Solicitors. That's the show banker, as back in the day our lotto forecasters would say. Akia McDonald's has this one. Bravo, please, can you recommend a place for me to do my NVQ level 3? I think you can consult KT Educational Consult. If you can put your thing on there, we can get the number for Akia McDonald. You can consult KT Educational Consult. For your IELTS, CELT, and all the other educational pieces of information, just call them on. Let me quickly. Man is growing old now. 07512644041. That's the information on the screen now. So take note of that and consult KT Educational Consult. They will be able to help you here. Okay, now we're picking up all the other bits as well. 07399208468, 07950422780. Lawyer, if I put in a long residence application and it's refused, do I have the chance of appealing? Oh, we lost your sound.
Hello?
Yeah, we can hear you now.
Yes. Yeah, I'm here, Rakoko. Yes. So if you can ask the question again, please.
Yeah, what I mean is when you're putting 20-year long resident leave to remain application, if it is refused, so to speak, do you have the chance of making an appeal?
Yes, there's right of appeal.
Okay, all right. From the explanation, maybe going through my mind, from the explanation is a tick box thing. So if it would be refused, then it means that either they are not accepting your evidence or you have not supplied all. Could that be the case?
It's always the case that you did not supply all,
Okay.
or you relied heavily on friends and family, and God that carries less weight. They did not consider that.
So in that case, it will be an outright refusal, but you have the right of appeal.
Yes, you always have the right of appeal.
All right. Okay. Now the text numbers again. Because of studio refurbishment, folks, we are not doing the phone calls now, but in the next couple of weeks, we should be able to come back to our norm. So don't worry about that. I'm expecting a baby this year, and my wife is in Ghana, and I was in Ghana 6 months ago. I hold 2.5 years card. Can I apply for the baby when my wife delivers? And if so, how?
So can you leave the question on the screen so we take it in turns? So this person is expecting a baby. That means expecting a baby, and so I was in Ghana 6 months ago. So that means they are here in the UK. She holds 2.5, so has limited leave to remain. Can I apply for baby when my wife delivers? So is this the husband who has the 2.5 or the wife?
Yeah, I think it's the man who says he has 2.5 and has a wife who is about to deliver.
So what has the wife got at the moment? Anyway,
the wife is in Ghana, so the wife is not here. But what he is asking is, he has 2.5. So if the wife delivers wherever in the world, what
Right,
status
right,
would the
right,
child
right.
acquire?
All right. The child will be a Ghanaian if this person is a Ghanaian, and the mother, of course, is also a Ghanaian. Because the person
Mhm.
doesn't have indefinite, and the person doesn't have citizenship.
Okay. So if for instance he wants to bring a wife and a child in, they will both be given 2.5 years as the father has.
Yes. So technically, if you are bringing your wife, you must have settled status or national citizenship. But there are instances where you have limited leave, you need your wife to be with you. You put in the
Hmm.
application. For children, we know that you can apply for your child to join you if you have limited leave to remain. But can you apply for your wife to join you or husband to join you if you have limited leave to remain? That is something that we can test the law with. And I say we test the law with because it's a matter of human right. And on that compassionate grounds, can my wife join me even if I have limited leave to remain?
Okay. Um, Listen, if you just joined us, we have had a discussion on how to make a 20 years long residence leave to remain application successfully here in the UK. Lawyer Charles Asma, our guest, and our resource person from our sponsors, BWF Solicitors, has unpicked all the very details that we need to have and has told us how to go about the application. There's a time for you to send in your questions, your concerns, and he is ready to address them. So you can send a text to 0739920848 or send a WhatsApp message to 07950 or text 0739920848. Lawyer Charles Osma is here. Lawyer Osma, when you apply for the 20 years long residence, and for instance, your family outside of the UK, yours is granted. One, what is granted you? Is it an indefinite leave to remain that is granted you a limited leave? And when that happens, would it cover your family outside of the UK?
So if we can break your question down. So this is
Mhm.
somebody who is resident in the UK and want to bring their family. Is that the case?
Well, he has applied for 20 years long residence, yes. So he's a resident. But what I added was what kind of residence would the person have after the 20 years long residence? Is it limited leave to remain or will go straight to indefinite?
Right. So let's deal with this person first. We have established
Hmm.
that this person who has applied for regularization under paragraph 276 will be given 2.5 and will have to run for 4 times. So that will take the person to 10 years. And so the person will be placed on the 10-year route and will stay for 10 years. So by the time the person is due for indefinite, they would have lived in the UK for 30 years under the current rules. Now,
Hmm.
having lived in the UK 20 and now plus 10, you get indefinite leave to remain and they continue their life. In between, they want to bring their family. And I think that is similar to the question that the person before this one asked, that I have 2.5. Can I bring my spouse and children? And we said that if you have 2.5, you can bring your children, but the rules as they stand do not permit bringing your spouse if you have 2.5. However, it's a case of human rights. Can my family join me under Article 8? The answer is yes. If that's the case, I have limited leave to remain. Can I still go ahead? It's a case of testing the law to see, because the rules simply say you must have settled status or you must have indefinite leave to remain. But if I have have either indefinite leave to remain or citizenship. But if I have 2.5, can I still go ahead? That is something you would test the law with. And there are instances where, based on a person's circumstance, will be granted.
Well, I have a friend and a lawyer friend who is so daring. Test the law. Yes, and that's what BWF Solicitors does. We see the law, and if it is that it is not too clear, there may be some gray areas. We'll test the law and see how the interpretation will go. Now let's go to this one. I have applied for fee waiver. I did that a month ago. My visa has expired and I haven't heard from them. What should I do? I'm on the 10-year route. Thank you, lawyer.
Okay, so the rules are that once you apply for a fee waiver, your application starts from the date you submitted a fee waiver application.
Right.
So once the fee waiver is decided, you have 10 days to submit the main application. Whether the fee waiver was granted or not granted, you have to submit within the 10 days, 10 working days. What it means is that you'll be given 10 working days to organize yourself and apply so that your visa period will continue as though it did not or it hasn't expired.
Okay.
And again,
I believe
there are provisions where, for example, for whatever reason, the person even forgot that the visa is expiring yesterday and they discovered today the visa is already expired. What can they do? They have 14 days within which to apply. And those are the grace period for those exceptional cases where your visa expired and you have just discovered that your visa is expired, but it's expired, the expiry is within 14 days. Therefore, you can still apply under the relevant provisions of the law.
Now, that grace period, let's see how we can define it quite properly. Now, when it has expired, within the 14 days, if I put in an application and it has not been decided, I wouldn't be in trouble because I've put in an application, correct?
So we always look at date of application, not date of the decision.
Okay.
The decision can take forever, but the date is paramount. So if the application was made before the visa expired, then the application was made in time. If the application was made after the visa has expired, we want to see whether it falls within the 14 days under the relevant provisions. If it doesn't fall within the 14 days grace period and it is after the 14 days, then the application was made out of time. And therefore, at the time you applied, you didn't have the right to live in
To
the UK.
remain in the UK. 0739920848. That's for our text messages. And for WhatsApp, 07950-422-780. 07950-422-780. But remember, if you call in BWF Solicitors, the office number is 0208-493-7340. And the emergency number 077-127-61884. Today we've discussed how to make 20 years long residence leave to remain application successfully, and we're grateful to Asma for his time and the knowledge and experience he has shared with us. Trust BWF Solicitors to do all this for you, and that's why we call them our trusted friends when it comes to the law. We will very soon be going on to our quiz segment, and that will be based on the nugget that we read about the deprivation of your British citizenship. Let me go through that again with you and let you know what it is that we looked at from Section 44A of the British Nationality Act of 1981. Now, deprivation of British citizenship is a decision to deprive someone of their British citizenship, even where it would leave them statesman, and this can be stateless, and this can be made if they have conducted themselves in a manner seriously prejudicial to the vital interests of the UK, and if there are reasonable grounds for believing that the person is able to become a national of another country or territory. This is being brought to you by BWF Solicitors. This is their message. We'll be right back.
This is our world. Here we are in our community. There are the laws, there are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214-218 High Road at Seven Sisters in North London. N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Okay, we are right back and into our stride. We're going to go to our quiz and also see if Queen McDonald's has come up with a question. Lawyer, with your indulgence, I will we'll go on to that. What are the requirements to renew your application if you're not working with your employer who gave you your certificate of sponsorship? What are the requirements to renew your application if you are not working with your employer who gave you the certificate of sponsorship and the new employer too hasn't given you any costs as well?
Right. So there will be no new employer if the new employer has not sponsored this person. So if there is new employer, they will be looking at a new course for new sponsorship.
No.
Now, the old employer is the one whose name is on the sponsorship card. At the end of the period, the employer is supposed to renew the sponsorship so that they can continue to work with this employee or this person. If for whatever reason it is not renewed, then that is the word, not renewed. If it is not renewed, then you cannot work for that employer, then you cannot remain legitimate in the UK. If you know that this is going to happen, then make sure that you find a new employer and you switch to the new employer so that the new employer will then take over from the old and you will have the certainty that at least it will be renewed once the 3 years or the 2 years or whatever period on your sponsorship is up.
Right. Thank you very much, lawyer, for your response. And obviously, I know that if people have issues with the certificate of sponsorship and would want to find out what there is, they can contact BWF Solicitors. The number is 0208 493 7340 or 077 127 61884. With that, and we have almost just about 20 more minutes to the end of the program. So let's see what question I have for you. And here it is. I know one of my very regular and favorite viewers and listeners will be thinking that I'm taking him on. Kofi Antobam. This Kofi Antobam was born in the UK in 1979 to Ghanaian parents. Kofi has never held a Ghanaian passport or been to Ghana. Kofi is therefore a British citizen, other than by descent. In April 2023, Kofi was convicted of a serious offense of fraud. Kofi subsequently received a notice of deprivation of his British citizenship from the Secretary of State for the Home Department on the basis that his conduct was seriously prejudicial to the vital interests of the UK. In addition, although Kofi has never held a Ghanaian passport or visited Ghana, the Secretary of State for the Home Department said he can reasonably become a Ghanaian. He was asked to leave the UK for Ghana. Kofi decides to appeal. Now, let me give you the scenario again. Kofi Antobam was born in the UK in 1979 to Ghanaian parents. He's never held a Ghanaian passport or been to Ghana. He is therefore a British citizen other than by descent. In April 2023, this year, he was convicted of a serious offense of fraud. Kofi subsequently received a notice of a deprivation of his British citizenship from the Secretary of State for the Home Department on the basis that his conduct was seriously prejudicial to the vital interests of the United Kingdom. In addition, although Kofi has never held a Ghanaian passport or visited Ghana, the Secretary of State for the Home Department said he can reasonably become a Ghanaian. He was asked to leave the UK for Ghana. Kofi decides to appeal. Can Kofi succeed if he appeals against the decision of the Secretary of State? Three answers, three options to choose from. Yes, because Kofi will be stateless if the decision is allowed to stand. No, he cannot succeed because Kofi is also Ghanaian because of his parents. And three, yes, because fraud is not a serious offense to warrant deprivation of citizenship. So can Kofi succeed? Yes, because Kofi will be stateless if the decision is allowed to stand as one option. No, Kofi cannot succeed because Kofi is also Ghanaian because of his parents. Or the third one, yes, because Kofi will succeed because fraud is not a serious offense to warrant deprivation of citizenship. Well, let's see what answers you have. You can send a text to 0739926848 and or well, so to speak, or you can put that in a comment down below or send it to our WhatsApp number 079504222780. Covenant Grace says Kofi is still Ghanaian. Kofi is still Ghanaian. So that goes to what? Number 2. So Kofi will not succeed. Promise says no, Kofi will not succeed because Kofi is Ghanaian because of his parents. What other answers do we have just before we go for the explanation from lawyer and we see who has gotten it right? 079504222780. You can put it in the comment section below, either on Facebook or WhatsApp or YouTube, so to speak. Let's see what answers you have. Let's get going. Let's get cracking. Who else is coming? Who else is coming? Let's get cracking. Let's get cracking. Promise has come up with another answer to say no. Kofi will not succeed because Kofi is also Ghanaian because of his parents. Who has a different answer? Covenant Grace says Kofi is still Ghanaian. Yes. So it goes to say that number 2 is the answer. Let's see what you have. And there we go. What answers do we have? Okay, time and tide they say waits for no man, and can never be exceptions to this one. So let me go to lawyer and see how we can unpick these and see which one is the correct answer. Lawyer's man.
Right. So it's good to see that there has been very, very good participation from the students. We're referring to the viewers and listeners. So very good. Well done to everybody who voiced out what they thought. So the rules are clear. Section 40, subsection 4A of the British Nationality Act 1981. Has Kofi committed an offense that is not good for the community of Britain? Yes. Fraud. Can the Secretary of State take Kofi's citizenship away? Yes. The rules allow for that. Is Kofi stateless? And is there reasonable belief that Kofi has somewhere else to go? That is the test now.
Mm-hmm.
Kofi is not stateless because we are told that Kofi's parents are Ghanaians and Kofi has never held Ghana passport. You don't have to have passport to be a citizen of a country. Passport is not compulsory. So Kofi is a Ghanaian through his parents. The law says that if the Secretary of State has reasonable belief that Kofi will have somewhere else to go, then the provision will be okay. Kofi has somewhere else to go, that is Ghana, because of the parents. Therefore, if Kofi were to appeal, will he succeed? The answer is no, because he has somewhere else to go, which is Ghana, and because he's a Ghanaian through his parents.
Well, Mina Nkuma, you just brought in your answer. Mina Nkuma says is number 3, which says that yes, because fraud is not a serious offense to warrant deprivation of citizenship. But as lawyer has explained, yeah, Kofi will not succeed because he's Ghanaian. Kofi will not be stateless because the Secretary of State has reasonable grounds to believe that Kofi can come from Ghana because of his parents. Kofi will. Fraud is a serious offense. Fraud is serious. So Kofi has no chance with that. So as it has been highlighted in red, the answer is no. Kofi is also Ghanaian because of his parents. Now, if we go back to the text that explains that, lawyer has gone with that. So if you want these details, you can send you can send a request to our WhatsApp number 079504222780, and we'll send this to you. But when you go to our social media platforms, LinkedIn, YouTube, Instagram, and all that, these are there, and it comes out by 12 noon every Monday. And coming Monday, there will be another topic for us to look at. And when we have put that down throughout the week, when we come on the community and the law on a Saturday afternoon, we'll test your knowledge to see how well you have followed that. So all of you that answered that number 2 is correct. Yes, no, Kofi is not stateless. He can be traced to have his roots in Ghana, so his appeal will not succeed. Kofi Atobam, don't do the wrong thing. And that goes to everybody to say that if you have a British citizenship status, don't take it for granted and get yourself involved in things that are criminal and can go harm the state of the UK. The Secretary of State has the right to take that away from you. Now, today we have been discussing how to make a 20 years long residence leave to remain application, how to do that successfully. Lawyer Charles Asma, our resource person, has done grace to that. Lawyer, maybe a quick response before we round up. We just have a few more minutes. If you want to renew your application and you're not working with a company that gave you course, what are the requirements? I think lawyer has answered that when Akia McDonald came with that answer. But in any case, I don't know whether lawyer you want to do a snapshot of that.
If you want to renew, you have to obtain a new course from the new employer, and you have to go through the process that you followed to get the first visa from abroad. Now that you are here, you don't have to go back home. You can stay here and have a visa application done. So you are switching from old to the new, but you need the sponsorship. You need the course from the new employer.
Okay. Now, to one of the requirements of the certificate of sponsorship is to write your English language. So you can contact a KT Educational Consult for them to help you. I am a Ghanaian. My British wife, who is also a Ghanaian descent, came to marry me and brought me to the UK. Now I've got British citizenship. Marriage is broken down, and I have applied for divorce 4 months now, but no decision yet. I went to Ghana in February, met a new lady I want to marry and bring her to live with me. Please, is it possible to contact family in Ghana to go to the Ghana court and apply for divorce for me because the marriage was done in Ghana, or I need to go to Ghana myself and apply for it, though the UK's divorce application is pending. Please, will the Home Office accept divorce made in Ghana's court? So can marry the new woman? I need advice. Well,
All right. So our friend has found new love. He wants to start again.
mm-hmm.
As the law allow that. Yes, the law allows for him to start again. However, which one comes first? He must divorce the old wife and go for the new one. So if the divorce has not completed, he has to wait. First things first. Once the divorce certificate is issued, he can then progress to marry the new um, fiancé or marry again. The marriage can take place in Ghana under customary laws of Ghana or under the ordinance laws of Ghana. If he chooses to do the ordinance law, under the ordinance law, he has to be there so that both of them will attend the ceremony. Bear in mind, they should also have met before the marriage, and therefore, I'm sure they have already met. So the physical meeting or encounter is ticked off. So first thing, divorce proceedings should end. He's already started divorce proceedings, and therefore I'm not sure why he would want to start again. So he should wait for the proceedings to end. He needs just patience to go through the process properly.
Okay. There's one very interesting topic I'm contemplating as looking at. Lawyer, the marriage vows that are said in church. Somebody brought up some very interesting arguments some time back, but we'll be looking at that later on, and the marriage and divorce issues will be dealt with. So keep your fingers crossed and watch the space. The community of the law brings you various discussions on aspects of the law, especially here in the UK. With that, I'll go to Lawyer once again for the summary of our discussion today before I draw the curtains down.
Thank you very much, viewer and listener, for keeping faith. Today, we've looked at a very interesting topic. How do I regularize my stay, having lived in the UK illegally for 20 years? The laws allow for you to regularize if you have lived in the UK illegally for 20 years. And the law is paragraph 276 ADE of Appendix FM to the immigration rules. What it simply means is that having lived here illegally, you can to regularize your stay. Now, to regularize your stay, you have to prove each year of the 20 years. It doesn't matter. All you need is just evidence, document to show your name, the location, which is the fact that it was issued in London or UK generally, and the date. The date will show that it's part of the 20 years. The location will show that you were in the UK, and your name will show that yes, it applies to you. If you're able to do this, you'll be ticking the boxes for each year. What sort of document do I need? Photos bearing, of course, your name. The photos usually will not have your name, but your picture in the photo will show that yes, you are the one. As again, the date of the photo and where the photo was taken are very important to prove UK and the date within the 20 years. And if you have worked along the line illegally, of course, you needed to survive, and therefore you did that. Even though it's an offense under the immigration rules, you can use it to prove a case that you have lived in the UK during that period. Now, 20 years does not count, or the years of imprisonment and the years you've left the UK do not count towards the 20 years. So when you are counting, start from the date you entered the UK and count 20 years. And any date you have been in prison, you have to deduct. If you came and left, then you are going to start again when you returned. So those are the counting period aspect. Now, in terms of the evidence, it must be a documentary evidence. Can I rely on friends and family? Yes. However, the Home Office will place very little weight to that evidence. What if I go to court? Will I win? Yes, if you go to court, you will win because the evidence from friends and family, the court will take into account. And also, the Secretary of State will have to bring something to show that they know that you left the UK. If there's nothing like that, then it will be difficult for them to prove their case. Is it worth trying? It is very, very, very good that once you are 20 years, you consider your application starting, and even if they say no, you can go to court. What if I'm not 20 years, but I am seriously ill? Can I make the application? The rules are simple, 20 years. However, if you cannot wait till 20 years because of your ill health, then you apply making reference to insurmountable obstacle that if you were to be removed from the UK to your original country, you'll not be able to survive because of the nature of your ill health. And therefore, you should be given some special consideration in this regard. And that is only when the Secretary of State may use discretion. So that is where discretion comes in under this rule. Otherwise, it's a pure tick box exercise. So if you are not 20 years and you are making the application, ask yourself, what special issue do I have for the Secretary of State to consider to give me favorable discretion? Otherwise, wait till you are 20 years. Can I use the applications I did in the past and the court dismissal notices and all that as part of my application? Can I use tenancy? Can I use GP cards and all that? Yes. Everything that has your name, everything that has a date, everything that has address that was issued in the UK will help your case. Make sure you tick the box for every year. How many evidence do I need for every year? I would say if you break the year into 4 quarters, make sure that you have evidence to cover each quarter. Therefore, each year you must have about 4 pieces of evidence. Therefore, 4 times 20 will be 80 pieces of evidence. Should they be the same? It can be the same, but it's better if you have various or varied evidence. So that is the conversation for today. We wish ourselves all the best for the coming week. If you are still not sure what to do, please do not hesitate to contact BWF Solicitors. Ask to speak to us, and we'll be very, very happy to assist you in any area of law that you need help with. Once again, pleasure coming your way.
And I have the honor of saying that we are so pleased to have BWF Solicitors as our legal partners. And I'm happy to say that we have enjoyed so much the discussion this afternoon. To Lawyer Charles Asma, thank you so very much for your time. And to all the lawyers at BWF Solicitors, starting from the principal to the case workers and all the support workers, want to say thank you so very much. To Sheila Ankara and Patmo Dodu for your wonderful work. To the staff of BWF Solicitors in Accra, thank you so very much. And of course, to my studio director and producer, Professor Ade, for your wonderful guidance and support. My name is Oreku Frimpong. This is the end of the show for today. We'll be back again same time next week on the same platform, BWTV, with another edition of The Community and the Law. Good evening.
Jesus, you're my everything, yeah. My everything is you, Lord. Yeah. Oh, 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 oh. Everybody say, yeah.